Testing. Testing, 1, 2, 3. Hey, Nicole, can you hear me? Oh, I can hear the typing.
Oh, can you hear me?
Yep.
Okay. So how do I mute myself? Because I don't want to, I'm just going to listen to take notes, but.
I'm not sure how you can mute yourself. I can mute you right now.
Hold on. Let me see. Let me know if this worked. Hold on.
Yeah, you are now muted.
Okay, great. So it's just a button.
Okay.
All right. Is your VPN desktop working yet, Joe?
It is still not working.
Mine too.
Yeah, no surprise there.
No, but we keep getting those emails from the Chief Justice. They're doing what they can, so whatever. I sent myself some stuff home. At least you can get eCourts public access, I guess, right?
Yeah, we've got that, and I mean, Zoom's on my local machine, so it's not a problem.
Yeah, I just did that too. I just downloaded Zoom. Great. Great.
I guess we're just waiting for the judge.
Is Matt here?
Matt doesn't need to get on because he's in the courtroom with the judge.
Oh, that's right. He's there today. Oh, yeah. Ooh. Oh. Yep.
Hey, Judge, can you hear me?
Yes, I can.
All right, I can hear you. I can see you just fine. Right now, we have 8 people waiting to come in.
I'm here, Judge. I'm just going to be muted so I can take some notes behind the scenes.
All right. Yeah, we're looking to schedule part 2 from 3 to 4:30 on the 31st of March.
Okay.
All right, looks like we got 9 people waiting. I think there were going to be 12 total, but it is 2:30, so I guess I should kind of let everyone in at this point, huh?
Go.
All right, I'm going to mute myself and mute Nicole at this point. All right, we are now live with the oral argument on Ashland.
Good afternoon.
Good afternoon.
Hold on, we're just doing a mic test. What? No, this is from 2:30 to 3:30.
Yeah, I know. I'm saying it's already recorded.
All right. Okay. So this is the Ashland. It's 2:30, Matt. We got to start.
Okay, I'm just trying to find the mic.
All right, this is the Ashland matter, MRS-L-2331-15. And I know we got a lot of counsel. So what are some of the appearances for the record?
Good afternoon, Your Honor. This is Jonathan Oblak from Quinn Emanuel on behalf of the G1 parties. I'll be doing the bulk of the arguing today. With me, I think on the phone as well, are Mr. Giles, Mr. Gillespie, and Mr. Rossman.
Good afternoon, Your Honor. Josh Elias from Gibbons. I will do arguing today on behalf of the Ashland and are William Hatfield, Camilo Otero, Zach Antoletti, and Jennifer Radel.
Good afternoon, Your Honor. This is Jamie Katz-Sussner from Sills Thomas. We are co-counsel for the defendants. My colleague, Matthew Lippert, is also on the phone.
All right. I just want to make a couple of statements, give everybody a chance to go over things. Where do things stand? And I'll hear from, let's just make it easy, plaintiff's counsel in the Delaware litigation.
So, Your Honor, this is Josh Elias for the Ashland parties. We represent the Ashland parties in the Delaware litigation that concerns the Linden site property. And we recently, I think on February 25th, received an order and opinion from Judge Davis granting the Ashland parties motion for summary judgment in part, denying it in part, and denying the defendant's summary judgment motion in full. Essentially what Judge Davis did, he granted the motion as to the Ashland party's motion on the contract claim. And at this point, the parties are scheduling a conference with Judge Davis to see what, if anything, remains to be done in the case outside of a damages hearing.
All right. If someone could perhaps upload that order and decision so I can have access to it, that would be appreciated. Or theoretically, it could be emailed. I don't know if there have been prior emails to my secretary at his work address, but he can also post his work email on eCourts if you'd prefer not to put that opinion up on eCourts. So two options that way. He's listening right now. In the Delaware litigation, after Boyer issues his decision in 2018, were any of these folks who were involved, any of the shared counsel people, were any of them deposed?
Yes, Your Honor. I believe Celeste Levine was deposed and Jason Pollock was deposed. But there's probably one other issue that we should disclose to the court that resolved a lot of, there was a lot of motion practice early on in the case about those joint privilege documents that ultimately would later become moot because later in the year the Heyman parties decided to waive their privilege over a certain category of documents. So a great deal of the documents that, maybe even all of the documents that that Special Discovery Master Boyer held were not subject to the joint privilege, particularly those deal documents. The privilege over that was effectively was waived and ended up being produced. Special Master Boyer did find that the bankruptcy, the G1 bankruptcy documents, that the Ashland parties didn't meet their burden on that claim. But if Your Honor looks at both of not just our brief on that point, but the G1 parties brief on that point, I think all parties understood that what the Ashland parties were actually seeking were due diligence documents. That case had to do with the SPA and the negotiations around the SPA. And we were looking for documents relating to the due diligence. And it happened to be that in the chart that we submitted with our motion, it captured some documents from the 2007-2008 timeframe relating to the bankruptcy, which were not really at issue. We never made an argument for those bankruptcy documents. So ultimately, in the opinion that you read that was on the record, even though we never actually expressly requested the G1 bankruptcy documents, he said we hadn't met our burden and were not entitled to those under his joint privilege analysis. Obviously, we're talking about something very different here. What's relevant here, what's at issue here, and the joint privilege analysis that this court should undertake, we think that would be a little different.
Okay.
May I be heard?
No. Explain to me again why, unlike virtually every other case where these issues come up, the parties way back in July or August of last year would not consent to the appointment of a discovery master to deal with these issues. And whether or not at this point in time, if I can turn it around in 1 month, whether the parties would so consent. But address the first question first.
Sure, Your Honor. From the Ashland party's perspective, I think at this point in July, we didn't see a number of so many discovery disputes that were arising at the time. I think we had a dispute about the redactions, and we didn't even file a formal motion on that issue. We just sent some informal letters to Your Honor just to get Your Honor's guidance. And then the privilege issue arose over the course of the spring and into the summer. Those were really the only two discovery issues that arose. So at that point in time, I don't think we saw a need for a special discovery master. Given the current circumstances, given our current discovery schedule, and also given the fact that we now see some additional discovery disputes relating to depositions that are going to likely arise and seem to be percolating already, the Ashland parties would be agreeable to the appointment of a special discovery master in this case.
All right. Yeah, I didn't say it by means of criticism. And let me add too. I was on 1 or 2 informal calls earlier, and I certainly expressed to all the attorneys on those calls, as I think I should on the record to you folks, that there's a lot going on in the world right now. And while this is an old case, I think we have to sort of take a back seat a little bit to what's going on. And the idea that everything can be done in a relatively short period of time may not be feasible unless we see things change in the near future. And most of you, I think, are participating telephonically. And while I'm in the courtroom right now, this may be my second to last proceeding that I conduct in a courtroom for a significant period of time. So a lot of things going on. Let me ask on behalf of the G1 parties, is there any objection to the appointment at this point relating to this issue and other issues of a discovery master to really be in a better position to help everyone manage these things? And one of the reasons I say that is while the court and the efforts have been Herculean, really, on the part of the chief and the director, and within our vicinage, our own assignment judge to manage things, to allow judges, some of them more tech savvy or less tech savvy than others. I guess I should say less tech savvy, coming out of my mouth. So we can conduct proceedings telephonically and accommodate things and move things forward. And I'll certainly make my best efforts in that regard. But I just don't know on an ongoing basis if the platform exists. Let's say in the best of all possible worlds, this is a relatively short-term issue in terms of the courts. And short-term may mean early June, okay? Whether or not the court has the platform from which to address issues on more so of a real-time basis, as opposed to those issues being addressed by a member of a relatively large law firm or the like. So let me hear from one or both. Well, from one G1 counsel on just that issue of a discovery master. Also, in light of the fact that apparently, and I'm sure it was a limited waiver, or it was characterized as a limited waiver over in Delaware, especially in light of the fact that G1 apparently has waived some of the issues or the privilege or the lack of privilege claims.
Yes, Your Honor. Again, Jonathan Obuck of Quinn Emanuel on behalf of the G1 parties. As far as the discovery master, I don't think we have any opposition to the appointment of one. I do think from our perspective, the law on Teleglobe is clear here, and that the testimony of the witnesses that's in front of the court by certification is certainly on its own sufficient to defeat Ashland's motion and the suggestion of a joint privileges to these documents. But as far as the voluntary waiver, I'm sorry, I get a little bit of echo. Can folks hear me?
Yes.
As far as the voluntary waiver issue, that is entirely a red herring. It had nothing to do with any of the documents at issue here, which involve communications relating to the G1 bankruptcy. None of those documents were waived at all as part of voluntary waiver. And so that really has no bearing at all on this analysis. And in fact, I disagree certainly with Mr. Elias's presentation of their pursuit of documents in front of Discovery Master Boyer and their suggestion that his decision should not be considered seriously here. Because in fact, if you look at the privilege log entries, many of these documents that they sought, among their broad challenge to privilege, related both to LCP and the Linden property. And so the suggestion that they weren't after those documents that dealt also with Linden, but involved communications with bankruptcy counsel, it just doesn't hold up. So certainly Discovery Master Boyer understood them to be challenging bankruptcy documents. There were more than 50, I believe, among those that they challenged, and he found that there was not a joint privilege as to those communications.
All right. Just in going through things, what I did is I just started to establish some templates and general principles. Obviously, reread Teleglobe. It's funny. When I read Boyer and then read Teleglobe, they do make the recommendation in Teleglobe that you look at Restatement 14, but Boyer really ran with that because it's not as prominent in Teleglobe, a discussion in that area, as one would expect when you kind of looked at the way Boyer went from Teleglobe to their analysis. But be that as it may, we're living in extraordinary times right now, and this is obviously an important case to everyone involved. And the last thing I want to do is maneuver things in such a way that I'm not providing an air of certainty, or I'm not in a position to really assist or move the case forward, as perhaps I would be if the circumstances in the world were a little bit different right now. And one of the concerns too I had is, what depositions have been taken in this case? Because certainly, as to all the Levine and Wills and Pollock and all these people, in hindsight's 2020, I could have denied or rejected all these motions to compel way back when, and just said, take their depositions, ask them questions, lock in their testimony. And then once you lock in their testimony, then you fight over the documents a little bit. And then you let a court look at the document, because then you have your testimony. Yeah, they don't, listen, I don't care whether they're attorneys or not. Those affidavits were written by the attorneys in this case. They didn't write out the affidavits or type them out, hand them to someone and say, okay, submit it to the court. So can someone explain to me why the affidavits of all these individuals have apparently never been tested in our case by way of deposition?
Your Honor,
Your Honor, if I can address that. With respect to Ms. Levine, Ms. Levine, as Mr. Elias noted, she was deposed, as was Mr. Pollack, in the Delaware action. I think Ms. Levine was actually deposed for 2 days, one of the only witnesses.
Okay.
And there was nothing in her testimony to call into question any of the positions we've taken with respect to privilege. There was no effort by the Ashland parties to revisit any of those decisions. In addition, Dennis Toft of the formerly Wolf Sampson firm was deposed as well. So the Ashland parties have certainly had the opportunity to explore these issues with witnesses who have relevant testimony, and none of it has generated any suggestion that the materials that they prepared in support of either discovery motion, which is Ms. Levine's affirmation, or Dennis O'Grady's certification that was submitted in connection with a summary judgment motion. There's nothing to suggest that those aren't completely true and accurate.
All right.
Your Honor, this is Josh Elias. If I can just respond briefly to that.
Sure.
This shared legal department has been analyzed now twice by 2 separate special discovery masters in the Delaware action. What the Delaware courts have found time and again was that the shared legal department didn't differentiate and maintain strict ethical laws between the various corporate affiliates. So in other words, they didn't document when they were performing legal services for one entity as opposed to another, or more the circumstances here, when or if they were providing legal services to more than one entity. So what the court and what Master Boyer did is he looked at Teleglobe, he looked at the restatement, and yes, he took the restatement section 14 and sort of applied it to the Teleglobe case and to our situation here. And I think we have to look at our situation here a little differently than what was happening in Teleglobe. Teleglobe was a parent subsidiary situation. This is not a parent subsidiary situation. These are 2 separate organizations that just had common ownership with the same shared legal department. So based on those facts, Special Master Boyer, in a decision that was upheld by Judge Davis, found, he crafted a test. And the test was, if it implicates ISPs or IES's legal rights and obligations, and the shared legal department reasonably should know that ISP or IES would rely on the shared legal department to look after its legal interests, then the shared legal department is going to be considered to be representing ISP or IES. You don't need any sort of express manifestation of representation. Now what the G1 parties don't want you to do is look at any of that. They don't want you to look at the circumstances or the documents. They just want you to flat out look at their own certifications of their own counsel and say, just because they say so, then that defeats our motion. Ms. Levine is certifying that 10, 12 years ago, she specifically recalls that with respect to these issues, she and the rest of the shared legal department just took off their ISP hat and was wearing only their G1 hat. And it's just not the case. You can't do that. In a shared legal department who doesn't maintain strict ethical laws, it's really easy for an attorney to just turn around and say, oh yeah, for that communication, I didn't have my ISP hat on. I only had my G1 hat on.
But you do have to agree that understanding that from a strictly corporate structure standpoint, it's a little bit of a different situation. But Teleglobe does, kind of say, and Boyer again runs with it a little bit. Hey, we understand sometimes that all the I's aren't going to be dotted and all of the T's crossed. We'd like them to be, but they're not, because most of the folks working in the shared legal department aren't creating billable hours. They aren't creating timesheets. That maybe they should, but so they're not coding the work they do. You or back when I was in practice, but certainly folks like you guys, you're coding your work. If you're doing work for a particular client, you're making a record of that. You're not just sort of saying, well, these are all my environmental clients, or these are all my clients under a certain umbrella, or that's a bad example. If you have a particular client that you have 7 cases for, you're coding all of your work. But Teleglobe kind of says, well, you really have to do that, and are we gonna do a form over substance type an analysis and the like. So it does become a little complicated. Here's what I want to do. Two things. And I promise to give you a chance to talk and develop the record. I'm just going to spend a couple of minutes going through some questions I have that I'd like answered. Because of the technical circumstances, I have you guys until 3:30. So I'm only going to talk a little bit more. I'd like to lock in if we can. I haven't gotten formal approval from this, but I hope I do. If necessary, and if it's it will be necessary if we can't come to a consensus on some type of discovery master, I'd like to schedule another telephonic proceeding like this. I mean, I really pity anybody who has to look at my face. I'm looking at it right now. I thought I looked better in the mirror this morning, but apparently not. For March 31st from 3 to 4:30 along this same format. I have to, and I'm not able to get approval yet for that time slot, but I believe I will be able to. That's at least the request I've made. And but let me just go through a couple of things. And I'm going to just at this point work off the summaries that both sides provided by way of the slides. I really do appreciate what was provided. I think it's helpful for the court to gain a better understanding of things. Right now, when I look at Ashland's submission on the slides, I'm looking at page 4 right now, and it says 1991 assumption agreement. And one of the questions I'm going to want answered or addressed is when I go to the left side and as I run down, and it says remediation of the Linden site, all right? I just want clarification that that is just the Linden site and not at all related to LCP. The page 5 is the LCP site and ISP.
I don't know if anyone else has. All
Yes.
that was cut. Touch any of it.
Right. Let me just get through it, and then I'll give Ashland's counsel a chance to address things, and then counsel for G1. Is the LCP site and ISP?
Having technical difficulties. Can't
who's
hear
that?
anything about every step.
Who's having the technical difficulties? Mr. Oblak?
Sorry, Your Honor, this is Colin from the G1 parties. I think it's Mr. Oblak right now. Who's having difficulties?
All right. Well, I'm gonna try to plow through it as best I can. I anticipated this is going to happen in the sense that even though these are great platforms, these platforms, whether it's Citrix or some of the other companies, are going to be stressed to a point where I don't believe they have the capacity to handle it. I mean, I'm not a tech person. There's people I know who are.
Your Honor, whatever it is has gone. Whatever it is has gone away. If you could just repeat your questions as to slides 4 and 5, so I can respond after Mr. Elias does, I'd appreciate it.
Okay, on page 4, I just wanted to clarify that the Linden site, as referenced in the bottom left-hand corner, including liabilities for remediation of the Linden site, and these liabilities shown on the balance sheet for ISP Corp. Dated as of May 8th, 1991, that is just what I tend to call the Linden property as opposed to LCP. Going forward, why? When we look at the page, that was page 5. Page 6 at the bottom, even if IES assumed LCP site liability under the 1991 assumption agreement, how or why would IES have assumed LCP site liability kind of relates to the prior question. Again, the Ashland is kind of a trial primer. Does get into the joint privilege a little bit the way in. I felt on page 10 of their presentation that the shared legal department, I don't believe it's appropriate to look at it the way it was drawn up. There's got to be a line coming out there for ISP and IES. Again, and I really do believe these issues are best managed or addressed by a discovery master, because these issues are not going to go away no matter how I rule today or on March 31st. But there should be a line out from ISP. I think that if Teleglobe tells us one thing, it's like, you know what? Don't focus too much on the web or the internet address. The fact that it's .isp is certainly not dispositive on these issues. Again, I'm just going through the timeline of negotiations. I don't think I had any other particular questions on that document. If you go to page 20, and where it talks about Special Discovery Master Quinn's joint privilege ruling, and it says, I find that this bankruptcy carve out to the joint privilege rule does not apply to pre-closing privilege documents found in Wolf and Sampson's file as it relates to the LPH property. The question is, why wouldn't we apply that same logic to LCP under the circumstances? What's the difference? Where should the court look at these things a little differently? And then on the Quinn Emanuel submission on behalf of the G1 parties, again, very well done, as was the Ashland presentation, very much appreciated. If we go to page 5 and the top section, the shared legal department, per Celeste Levine was representing G1 only. Is this arguably contrary to Boyer's finding that regarding the providing of information to the DEP relating to the Linden property? In other words, what I just did is I kind of drew tables going down, DEP, EPA. It looked like and you know, different subcategories were created. You know, basically Boyer was, if it relates to the deal, if it relates to the SPA, it's not subject to the joint privilege. And I certainly understand that reasoning or logic. The problem is, what do we do where there's a mix, or what do we do within an SPA related communication or discussion? There's discussions related to the liabilities or the like relating to the LCP site as it relates to IES, ISP. Going to page 6 of that summary, under C. O'Grady cert at example 2, bankruptcy court's order appointing Riker and confirming that the firm represented no interest adverse to G1 estate. Just perhaps a little explanation as why that in and of itself should in any way be dispositive or persuasive for the court. I did note, though, the bottom line, the sworn attorney testimony in the bankruptcy court approved representations are dispositive, confirming that those firms, I mean, obviously that's a conclusory statement, did appear to be somewhat consistent with what Boyer was doing. Again, I kept coming back to the due diligence versus the deal as a real sort of tipping point or separate categories. On page 9, there was the top line where relating to Wolf and Sampson. I really do feel, Quinn looked at things a little bit differently, certainly than Boyer, but it is a different scenario that's in front of us here, I think, than Quinn was dealing with. And on the page 10, when we talk about G1's bankruptcy negotiations with the EPA, boy, I almost got that one wrong, relating to the draft stipulation did not reach a point where it was necessary to involve ISP, but why isn't that area analogous to the ISRA or NJDEP findings of Boyer? In other words, they're dealing with their bankruptcy negotiations with the EPA. Why should I look at that, or why, perhaps down the road, a discovery master? Why shouldn't they look at that in a certain way? Why would ISP retain their own? But here's the other point on the bankruptcy. Why would ISP retain their own counsel if they expected that their interests were being represented by the shared legal department? I guess that's one of the crux of these various issues that are presented. Again, the jumbling of things where Pollack is serving as legal counsel for ISP, apparently signed the consent decree on their behalf as a member of the shared legal department. Why isn't that? I know it's used by G1 as evidence going one way, but why can't it be used going the other way? And the first part of the consent decree, which limited any LCP related claims to 8.6%. Did this not work to the benefit of ISP in some sense or not? And when we say in the next paragraph, again on page 11, this result was more favorable for G1, was it also not arguably more favorable in some sense for IS? Maybe not, maybe not. But just kind of questions that I rolled along, and so there you go. Let me hear again. We're gonna. It's a hard stop at 3:30. I apologize for that. I'm gonna let you go. I'll talk to you for a minute or two at the end, just to ask you some of your thoughts. But let's hear first from Ashland's counsel. Address things in any way, shape, or form that you'd like, but I can give you till about 17 and a half minutes, or 17 minutes after the hour, so about 13 minutes.
Okay, thank you, Your Honor. The early slides really were placed there just to give Your Honor some understanding of the background of this case. I know we made some earlier presentations to Judge DeAngelis that you didn't have the benefit of, and you made some mention of relevance in the February 14th opinion. So we wanted to provide you with just at least some background of the critical transactions here. And I don't want to spend too much time on it because I know time is short. You know, the first one being the 1989 liquidation plan and the Dorset Edgecliff split. We think it went down the Edgecliff side. They say it went down the Dorset side. And then it comes to the 1991 assumption agreement, which Your Honor pointed out. The assumption agreement was a part of a larger reorganization, and this is sort of just one piece of it, and this is really what's critical here. And I think Your Honor put your thumb right on it. It's whether the Linden site reference is supposed to mean the Linden site as we know it, or as the G1 parties argue, they say it's all one site. Their argument is you get LCP liability went down with it, because of the Linden site was part of that. That's their argument, but I think that's part of the dispute here. As far as the 1996 indemnification agreement, that was signed following the 1996 spinoff of ISP, and there was cross indemnifications. And the Ashland party's position there is even if the 1991 agreement sent the LCP liability down to IES, well, the 1996 agreement entitles ISP to indemnity for that GAF liability. The G1's party's position there is that once the liability for the LCP site was placed down in IES from the 1991 agreement, that then at that point in time became an ISP liability that had to then be ISP would have to indemnify the G1 parties for. So that's, again, just another critical dispute that's at issue here. But ultimately, they got to be right on every one of those transactions. They have to be right that it went down Dorset, that the 1991 agreement sent LCP down to IES, that the indemnification agreement doesn't entitle ISP to indemnification, and then also that the 2011 SPA didn't terminate the 91 agreement. So our position is it's not listed in that term that allows for certain intercompany agreements to be continuing. The only one, the 1996 agreement was listed as continuing. The 1991 agreement was not. And so our position is once that 91 agreement is terminated, if LCP was down in the IES as a result of that 91 agreement, it reverted back to G1 at that point in time.
Understood.
So that's sort of the...
And that's where their
Sorry,
argument, and this will be my only interruption, but their counter to that is, and I don't want to hear from G1 right now, is that, well, okay, fine, but then why did ISP go to 2011 with the DEP and then 2014 with the EPA? Right?
Oh, well, the answer to that is pretty simple. IES was put on an administrative consent order with the EPA. So IES continued to perform that contractual obligation with the EPA. And once that contractual obligation was concluded, then there was no further obligation of IES because the actual LCP liability was the G1 liability.
Well, but didn't IES continue with that liability post-sale?
Post-sale only to continue the administrative consent order because they were contractually obligated to the EPA to do that.
Okay, and the deal says if possible, they're going to remove them. Okay, from the.
Well, the possible that I think remove them was the LPH ACO, which was a different issue.
Okay.
Yeah, Your Honor, this is Bill Hatfield. Just to clarify that the administrative order on consent with EPA for the LCP site is terminated. That work was ended in 2013, so ISP is no longer under an order.
Gotcha. Thank you.
The study is done, and that contractual obligation ended after the closing.
All right. You may continue.
So Your Honor then referred to slide 10, which is the shared legal department, and I think that's a crucial place where we need to start. Prior to August 23rd, 2011, when ISP was sold to Ashland, they all operated under this common shared in-house legal department, and they provided services to all GAF companies that were owned and controlled by the Heyman family, including the ISP parties. Now, these attorneys in the shared legal department, the reason it's depicted that way is because they're employed by IES. These were all employees of IES. They were paid by ISP. They were employed by ISP, paid by ISP. They used ISP service. They had ISP email addresses, and through a shared services agreement, they provided legal services to these other Heyman family-owned entities. So that's why it looks that way. And as I said earlier, the Delaware court has analyzed this twice. They've both looked at the same test that Special Master Boyer crafted as upheld by Judge Davis in Delaware, looking whether the matter implicates ISP or IES's legal rights and obligations, and whether the attorneys in the shared legal department reasonably should know that ISP or IES would view the shared legal department as looking after their legal interest there. So again, the G1 parties want you to just focus on their certifications, but you can't do that. You have to look at the circumstances. You have to quite possibly look at those documents in camera to really understand what matters implicate ISPs and IES's legal rights and obligations, and what the shared legal department reasonably should have known regarding those. So as far as the documents that we're looking for here, the documents that we're talking about, what we're talking about is the 2009 consent decree, which was entered in connection with the G1's bankruptcy, and that was also obviously signed by ISP, as Your Honor is aware. just to provide some background, there was proof of claim filed by the government regarding various environmental claims for GAF-affiliated sites, including the LCP site. And the United States filed an objection to G1's disclosure statement for its failure to disclose how the 91 assumption agreement would affect the proof of claim as it relates to the LCP site. So, in other words, the government wasn't convinced that the 1991 assumption agreement placed the LCP liability with IES. And that's not the first time that this came up. If we look at slide 12, back in 1998, EPA came to the G1 parties before, and that's after Linden Chlorine Products, who GAF sold the LCP property to. They went into bankruptcy. And so the EPA came knocking and asked GAF who took the LCP liability. And what came of that was two competing memos, which has been called the dueling memos, one by Celeste Levine and one by Emily Schultz, both in the shared legal department. They come to completely opposite conclusions as to where this liability went. Ms. Levine said it went down the Edgecliff side and was a G1 liability. Ms. Schultz said it went down the Dorset side and down to IES through the 1991 agreement. And ultimately, as a result of that second Emily Schultz memo, this led IES to be volunteered by G1 to sign that administrative order on consent with the EPA to perform the remedial investigation for the LCP site. And those memos were what the appellate division ruling was about. And the appellate division found that those documents were joint privileged, they were accessible to both parties, they could be used by both parties against one another in the litigation, they just couldn't be disclosed to any third parties. So now fast forward 10 years, G1's in bankruptcy, and the United States is asking the same question, who has this liability for the LCP site? But now the G1 parties are, when we're talking about these same communications, with the same subject matter, the same issue, with the same people in the shared legal department, now they're being withheld as privileged. And we can look at some of those on slide 13. These are documents that are about the dueling memos, about the same issue, but they're still being withheld as privileged. Now on slide 14, we see the objection to the disclosure statement that the United States filed. And it says the debtors and ISP, where they ask whether the debtors and ISP will stipulate to ISP's assumption of any liability arising from GAF's activities at or in relation to GAF LCP. Now that sets off this series of communications and negotiations in the shared legal department, and Riker Danzig, which was representing G1 in the bankruptcy, and they began negotiating with the Department of Justice on behalf of G1 and ISP to resolve that proof of claim. And if we look on page 15, in the course of those negotiations, the Department of Justice sends Riker Danzig a whole series of requests for ISP's confidential financial information, IES's confidential financial information, IES's insurance receivables, information on litigation involving IES, IES's corporate history information. And, in response to one of your questions on to the G1 party's slide, I want to refer you to something that Special Master Boyer said in his opinion on page 14 when he was talking about the due diligence documents. He said, in that situation, clearly the rights and obligations of ISP were implicated, and it did have an interest in how its documents were being shown to, third parties. That's exactly what's happening here. We're talking about confidential information, and the G1 parties are saying, well, ISP wasn't involved. There's no need for them to be involved. Well, we're talking about confidential financial information of ISP and IES. Of course they had to be involved, and the same people are involved. The shared legal department compiled this information in consultation with ISP personnel, ISP outside counsel, and provided it back to Riker. And Riker handed it over to the Department of Justice. And these were all communications that were centered around a new assumption of liability agreement, shown which we see in slide 16. And in this document, we see that this was intended to saddle ISP with environmental liabilities. It was going to foreclose certain defenses with respect to liabilities assumed by IES. And in return, the proof of claim would be withdrawn. The United States would agree not to sue G1 or its affiliates other than the ISP parties. And ISP would get a covenant not to sue from the United States for claims relating to the Vermont asbestos site.
All right, but but you could see a distinction between providing documents to the Department of Justice relating to ISP. And again, that falls within, I understand your argument, the Boyer, ISRA argument and the like, and the DEP. It's like, hey, wait a second, you're providing all of our documents or all of ISP's documents, and you're sifting through them and you're responding to requests. What client wouldn't expect that their interests are being represented? I'm not making a finding, I'm just understanding your argument, versus as they are trying to negotiate things in a way where they essentially shove it all off on ISP, they're clearly not, and ISP wouldn't expect that they'd be representing their interests in the second regard, right?
Well, and that's an interesting point. Yes, they're saddling ISP with a liability here, but I think we have to look a little deeper as to why they're saddling ISP with that liability. Because ISP, if they get the LCP liability, they have a very large insurance receivable that's coming their way. But if that liability goes to G1, who's in bankruptcy, that insurance receivable goes to that pool of money that's going to the creditors.
Okay.
And so there's this common ownership among those two entities who have a common interest in where they want this liability to go so they can get this insurance receivable. There's a financial interest on behalf of ISP here.
Your Honor, I just want to flag the time so I can have a
Right,
chance
it's about
to respond.
17 after. Let me hear from other counsel. Go to about 3:29, and then I'll talk real fast.
Thanks, Your Honor. So again, John Obach on behalf of the G1 parties from Quinn Emanuel. I want to touch on a couple of things. I'll run through the Ashland party slide. I want to address a number of the points. I'm not going to spend a lot of time on the background section, which addresses the kind of parties competing, well, addresses the Ashland party's view of the competing interpretations of the various agreements. Because I think I want to focus more specifically on the joint privilege issue. I do want to flag a couple of things along the way, which I think probably ends up being one of the issues we're going to have to revisit down the road. And that's when you get to, for example, page 8 of their presentation that has this flow chart of key legal issues and key legal agreements. I want to flag two things here. The first is in the big picture, Mr. Elias kind of portrays this as the G1 parties have to win on all of these issues to prevail. And the thing I want to make sure the court understands and appreciates from the background of this case is that all of the contemporaneous evidence supports the G1 parties' interpretations as to how these liabilities are distributed. There's a course of performance here that spans more than 20 years from ISP taking on the AOC obligation in 1998 through not just 2011 when the SPA was executed and Ashland purchased the company, but for years thereafter they continued to accept the liabilities and deal with them with the EPA. And then what's important to flag here that unfortunately we're going to have to revisit, I think, is this notion that the third leg of this analysis, the termination of the 1991 assumption agreement by the SPA in 2011. This has not been part of the case. This is part of the new addition that Ashland has tried to insert into the case when they filed their amended complaint. And while in fact this theory would certainly benefit them with respect to Linden, it is an alternate theory that they are offering on their own behalf here with respect to their LCP liabilities to argue that this 2011 SPA terminated the 1991 agreement. And I don't want to spend too much time on that because I think it's a distraction from the important issue here of the joint privilege questions. But this again is their insertion of an entirely new theory into the case, and we think that's precluded by their obligation to litigate the application of the SPA in Delaware. With respect to slide number 10, we certainly agree with Your Honor that the shared legal department should not be the epicenter of this hub and spoke, and disagree certainly with Mr. Elias's suggestion that it belongs in ISP as portrayed here. what they had on their business card or their email addresses does not dictate the analysis as to who the shared legal department was representing. I think Your Honor appreciates that from the scope of your questions, and I don't think it's a fair representation of that relationship where the shared legal department effectively is a law firm working for the common ownership of these various entities. And as Discovery Master Boyer found, it is a fact-specific inquiry, and you do have to look at the circumstances of each engagement to determine whether or not an entity is working individually, a lawyer is working individually for an entity, or is working in a joint capacity. Looking at slide 11, I want to spend a minute or two, again, on Boyer's analysis and Teleglobe. Mr. Elias has said a couple of times this notion that the attorney's subjective intent is irrelevant as portrayed on slide 11. This suggestion that the touchstone is really should the attorney reasonably have known from the circumstances. And I think Mr. Elias's emphasis on that is incorrect, in that what Teleglobe teaches us is that, yes, you can have a joint representation or representation generally by implication. But what Teleglobe teaches us is that you need to be careful not to construe that joint representation too broadly, too readily by implication. That's at Teleglobe at 362. We talk about it on slide 1 of our deck. And in fact, I think Teleglobe focuses more on this joint representation issue, obviously, than the restatement. And it's really Teleglobe's standard that you should be looking at the facts and circumstances which Teleglobe expressly identifies as including the party's intent and expectations, looking at testimony from the parties and their attorneys on those areas. That's on page 2 of our deck. So the Teleglobe standard really does place a great emphasis on the testimony of the lawyers in analyzing this fact-specific circumstances. And as I'll get to, we've been entirely consistent in how that joint privilege has been applied here and limited here. It does not apply to the G1 parties' negotiations and adversarial work with the EPA in relation to the G1 party's bankruptcy. G1 is the debtor. The EPA has filed claims against G1. The debate and discussion that G1 has with the EPA about who is liable for the various claims the EPA wants to assert against G1, that by definition is going to include other entities. It's going to include, for example, the LCP liability, where G1's response was, that's an ISP liability. That's been an ISP liability for more than a decade. And they have a discussion and negotiation about that. The problem with the Ashland party's analysis is this suggestion that discussing LCP's liabilities somehow makes it a joint privilege doesn't hold water, because G1 is going to be discussing all sorts of third-party liabilities that may come up in debating what the EPA can claim against them. That discussion doesn't somehow make every other party's liability a third-party discussion on that party's behalf. So just because G1 is pointing the finger at ISP for the LCP liability doesn't bring them into the fold of a joint privilege. And I think, as Your Honor notes, it reflects the adversarial nature of that discussion. So
right,
the fact that
we can go a little bit after 3:30, I believe, because I'm the next one up, and the other matter I have, no disrespect to the folks on that matter, isn't as complex or doesn't carry the same a level of import. But yeah, I'm a simple guy. And if the Department of Justice or the EPA wants documents relating to a particular company, my guess would be they want a full and complete set of documents. They may even want some type of affidavit or certification to the effect, listen, we are providing you with everything we have. And a corporate officer or designee will sign off on that. If they're looking for information from G1 relating to ISP's financials, management of certain property, why don't they ask ISP? Or why doesn't G1 say, hey, don't ask us. Don't ask us to verify or certify to ISP related information, you need to go to ISP. But once G1 undertakes that, doesn't that create a little bit of a sticky wicket or the like there?
Respectfully, it doesn't. It doesn't because the shared legal department, again, is operating at a couple different levels. It's representing, it's working on behalf of G1 in negotiating with the EPA, and there were particular lawyers who were undertaking that. Ms. Levine and Mr. Goldstein are identified by Ms. Levine. And the common ownership that has an interest both in G1 and ISP has a right of access to information from ISP, and there's no suggestion that any of the information that the shared legal department was able to collect from ISP to provide to the EPA was somehow provided inappropriately, that it didn't have a right of access to that. And so the collection of information and the types of information you're seeing are information about pending claims. And the reality is what happened with these discussions about the stipulation that the EPA wanted to enter into, the negotiations fell apart. And G1 decided it was not to its benefit to pursue that route, and it pursued the consent decree instead. And with respect to the consent decree, we produced documents relating to that, reflecting those negotiations and discussions. And just jumping to Your Honor's questions about the benefits of the consent decree, the benefits of entering into the consent decree, they accrued to G1. The limit of liability applies with respect to G1. That is not something that applies to ISP. And from G1's perspective, it was trying to wrap up loose ends and get the bankruptcy completed. It had the protection of that limitation of liability, the 8.6%. And it knew that ISP had been taking on and responsible for the LCP obligations for more than a decade. So the notion that it needed to proceed with this stipulation to resolve things, it just didn't make any sense. And Ms. Levine's declaration addresses this specifically, that had the stipulation gotten to a point at which ISP would have been asked to take some action, to make representations, to do certain things, then they understood and expected that outside counsel, Epstein Becker, would have been brought in to address that issue. So the way that the shared legal department dealt with this is completely appropriate. And if we want to talk about it, maybe we'll end up doing this on the 31st, some of the in-camera documents. The in-camera documents include discussions about communications that were had with the EPA, where Mr. O'Grady is relaying back discussions that he had with the EPA, explaining issues that are under discussion and negotiation. We think those documents are much more instructive of the nature of the interactions with the EPA than, for example, the Ashland party's attempts to spin documents in particular directions to support a theory that's contradicted by the sworn testimony.
Gotcha. Let's do this right now. I think we can go to 3:40, Matt, and then Joe will just tell him I'll be in that other call at 3:45. Can you text him? Because he's been good on his tag. He's probably listening to this right now. But he can unmute himself and give me the answer.
Well, I'm listening, Judge. You want me to let the other parties know you're going to go till 3:45 on this one?
Yeah, on CDOR, let them know I'll come in around 3:45.
Okay, will do.
Thanks, Joe. All right, let me hear from Ashland's counsel for 5 minutes, and then another 5 minutes from G1, and then we'll just talk for a few minutes about a going forward plan.
Thank you, Your Honor. Firstly, Mr. Oblak repeated something that he said on his last call, which wasn't on the record, and I think Your Honor corrected this statement, but now that we're on the record, I think it's important that we get it out there. We've raised the issue of the SPA terminating the 1991 agreement. Mr. Oblak believes that issue has been dismissed from the case as a result of Your Honor's denial of the motion to amend. We clarified on our last call, and Your Honor agreed that the only issue that was not permitted to be raised was the damages relating to the LPH site, which was being addressed in Delaware, but that we were perfectly within our rights to raise the issue of whether the SPA terminates the 1991 agreement as a response to their defense in this case. Is that correct?
I believe so. Now you're making me think too hard and going back.
It's very much an issue that warrants more conversation than Mr. Elias summarizing a phone call and asking you to agree. It is a very significant issue for how this case proceeds. Agreed. All right, you may continue, counsel.
Okay, Your Honor, you asked the question of, why didn't G1 just go down and ask ISP if, they were asking for all this information and this financial and confidential information. And the reason they didn't go ask ISP is because they're the same people. Celeste Levine and Daniel Goldstein are the two individuals from the Shared Legal Department who are doing this on behalf of G1. Celeste Levine is IES's counsel in the Shared Legal Department. Daniel Goldstein, and here, this is the kicker, Your Honor, Daniel Goldstein is the general counsel for ISP and IES. How is it possible? It is not possible for Mr. Goldstein, as the general counsel of ISP and IES, to have taken off his ISP hat and only worn his G1 hat and negotiated things that may be to the benefit or detriment of ISP or IES without considering them at all. It just makes no sense. It's a conflict. It's problematic, and that's exactly what Teleglobe counsels against and what it warns against. Teleglobe says, it is inevitable that on occasion parent subsidiaries will see their interests diverge, particularly in spin-off, sales, and insolvency situations. And when this happens, it is wise for the parent to secure for the subsidiary outside representation. And they didn't do that here. Mr. Oblak says, well, they would have gotten Epstein-Becker involved. Epstein-Becker was involved in, as far as we're aware, a single appearance for IES back in 2003 and never appeared for them ever again. And actually, when somebody signed these communication or issued this consent decree, it was a member of the Shared Legal Department. ISP and IES were relying on the Shared Legal Department for all of these negotiations. And it's clear. I'm sorry, go ahead.
Is this a de facto parent-subsidiary relationship, or is it something else?
Well, this is different from a parent-subsidiary relationship, for sure, but we're talking about a shared legal department. We're talking about the same people in the same department where the argument now is that we believe that this was a joint representation. There was a common interest, as we've explained. Their response is that, no, this wasn't. We were just representing G1. And if they were just representing G1, well, that creates the conflict. They're trying to argue that there was a conflict. That's their argument. We only represented one of these parties to the detriment of the other, and we were in a conflict. That's their response, and it can't be. What actually happened here is a joint representation. It's clear from the documents. And they say that ISP wasn't involved in these negotiations. If we look at let me get the right slide page for you. Slide 17. Riker Danzig is following a stipulation that he says ISP drafted. And the next page has communications between Celeste Levine and copying Daniel Goldstein, both IES in-house counsel and general counsel, to IES's outside land use counsel. ISP and IES were, of course, involved. They had to be involved. They're the ones with the information. They provided the IES narrative, all the historical background, IES's corporate history, all that information had to be from IES. This is confidential information. Who has the authority? Who has the authority to provide confidential financial information to a federal agency? Certainly not G1. If you want to respect, the corporate separateness, it had to be ISP. ISP had to be the.
Yeah, let me just. I think that I'm going to have to develop a note card system with this video conferencing, so I can hold up. No, but a lot of you are participating by phone, so maybe that won't work. But let me hear from a G1 for about 5 minutes, and then we'll just talk for a couple of minutes, and then I do have to go to the other matter. apologize.
Thank you, Your Honor. I want to start with a couple of points. First of all, I think what's clear from the Ashland party's argument is that they are trying to throw out the portion of the Teleglobe decisions that deal with how to address a shared legal department. And that's really what's key here, because Mr. Elias's argument that Celeste Levine and Daniel Goldstein can't wear more than one hat is the very type of havoc that the Teleglobe warns about if you imply a joint representation more broadly than the parties intended. And in fact, the suggestion that there was a conflict here and thus ISP's interest had to be represented is also refuted by Teleglobe. Teleglobe says you can't get to a joint representation by a mistaken belief. Your Honor noted that in his decision from February. Teleglobe also says that you don't get to a joint representation if an attorney happened to be acting in a position of conflict. Teleglobe reads, when an attorney improperly represents two clients whose interests are adverse, the communications are privileged against each other, notwithstanding the lawyer's misconduct. So the conflict doesn't get them there either, but there wasn't a conflict because the shared legal department can allocate roles in handling particular engagements. That's what they did here.
But should they be with different individuals? I mean, isn't it a chaotic situation where you're kind of saying, okay, it's Monday, Wednesday, Friday. I'm doing my G1 work. Tuesday, Thursday, ISP related work. Doesn't that create just a really difficult situation in terms of figuring out well who exactly are you doing this for? Right?
It doesn't with respect to this issue in the sense that there was a very discrete engagement, and that discrete engagement that we're looking at here is the negotiation of the G1 bankruptcy. And the role of the shared legal department, there were particular people who were working with outside counsel who was representing only ISP. We have that from Mr. O'Grady's declaration. It's also in the documents that are in front of the court in camera. So, for example, in tab 15 of the in-camera documents, this is dates ending 381. There's a document, and the description for the portion that's redacted is email correspondence between G1 company counsel and outside bankruptcy counsel, redacting legal advice regarding discussions with the USA regarding pending environmental claims against G1 in connection with the G1 bankruptcy. You have in front of you, Your Honor, in-camera documents that include those discussions that are taking place with the EPA that reference what's being discussed in communications among attorney and client, that identify what the roles are, that talk about these what is actually transpiring among the parties. So the suggestion by Mr. Elias that they're negotiating on behalf of ISP is just not supported. There's an exchange of information, and there's no suggestion, again, that the joint owner, the Heyman family that owns both entities, doesn't have a right to reach in and get access to information and decide what to do with it. That doesn't create a joint representation that you're getting information out of ISP. So the idea that collecting that information and providing it creates a joint representation is just not supported by Teleglobe, and it's not supported by the in-camera documents that reflect the discussions that are taking place, and it's not supported by the declarations of the attorneys who are involved in it. And coming back to kind of, I know I need to finish up, the touchstone of this is the intent and expectations of the parties. You have that in front of you, and it's fully supported by the in-camera documents and the explanations we provided as to the documents Ashland's identified, which I'm sure we'll get into further when we reconvene.
All right, so we're going to reconvene right now on the 31st from 3 to 4:30 in the same format. Let me just note for the record, too. I mean, having read the documents, I understand why you point my attention to tab 15. O'Grady clearly knew the difference in many respects, that's for sure. And he knew and appeared to be taking some pains to make sure that it was understood what role he was playing. Don't want to tip my hand at all, but I understand why that's an exemplar that would have been brought to the court's attention. I do want you to, it's funny. As all this stuff was unfolding in the world, and as it was throwing, I assume, most of our lives into some level of chaos, I actually said to myself that, you know what, I would rather be working on this case for the entire weekend than dealing with triaging family issues and other work-related issues and the like, brought on by the virus and the like. And I don't mean, I say that somewhat tongue-in-cheek, but it's true, because it's a very interesting case to look through. It's an interesting case to learn more about. I do believe the interests of the parties would be best served by coming to some sort of an agreement on a discovery master. That doesn't mean I don't have opinions or thoughts on these issues, but I'm trying to look long-term, not just short-term. I know, given the pace at which I've decided things, you probably look at me as kind of a long-term guy. That's not usually the case. But we've had certainly one issue after another. I want you guys to give serious thought to that issue. If you can agree on someone and that individual is able to turn this issue around in 1 month or thereabouts, I would certainly sign off on that. If you wanted to, you'd probably want to structure it the same way you structure things with SDM Boyer and Quinn in terms of appellate rights or the like, but if you wanted to structure it differently, that's fine too. I obviously don't have the authority or power under the relevant rule to impose upon you, nor would I even consider doing it, or would I ever even say anything or intimate that you guys better think of doing it this way. Not the way to get things done. If you could come together, reach an agreement on someone, great. I have just sort of ruminated. I've actually kind of looked at some other districts. This is usually, even though it started off as a relatively smaller issue, I think it's going to germinate, especially as a deposition discovery and the like proceeds. So I think it's, all I can do is ask you to consider it. That's all. I have communicated with someone I've worked with as a discovery master, who has told me that their office would be able to turn it around. It's Richard Bottolato, who used to be a partner at Connell Foley, was the former insurance commissioner. Not a direct background in environmental work, but kind of like a Tom Quinn, very smart guy, very savvy guy, and he's got a great platform to work from with Walsh Busy. But again, that's just one name that, I've kind of said to myself, listen, is this something that law firms out there are able to handle if someone's appointed, and do it in a way that won't cause you guys any further problems or delay? And that was one individual, one firm, who indicated to the court that, yes, that's something that even under the circumstances going on now could be executed and handled. So think about it, post something to eCourts if there's something more to discuss. Otherwise, we'll get a more robust 90 minutes next time, and we'll try and put a bow and a ribbon on things. But I do believe, well, I've stated what I believe. So I'm going to let you go at this point. Thank you for making yourselves available. Thank you for the slides. Thank you for the way the issue has been briefed and addressed. And I especially want to wish you and your families good luck and health going forward. And when in doubt, stay calm. And when that becomes difficult, just remember the line from Seinfeld: serenity now. I'm trying to remember it a lot, I'll tell you, but easier said than done. And again, I appreciate everything that you guys have done to present this issue to the court.
Thank you, Your Honor. Just before we let you go, is it safe to assume, as we try and talk about and discuss amongst ourselves a special discovery master to do some other issues and this issue as well, that this portion of the February 14th order is vacated?
Which was that which portion of that where I'm just trying to remember. I don't have the order right in front of me.
Right. So the opinion addressed both the redaction issue, the two motions to amend, and this joint privilege issue that we're discussing now.
Just the redaction joint privilege issue is vacated, not the motions to amend.
Right, but the other issues are vacated.
That is correct.
I don't know, because we haven't seen an order vacated. I just wanted to make sure we had that on the record.
All right. Maybe if a member of my staff who's listening in could put a draft order up, and I'll take a look at it Monday or Tuesday, and we'll see if we can get it out to you.
Thank you, Your Honor.
All right.
Be safe.
Thanks, guys. Hey, you too. Take care.
Thank you, Your Honor.
Bye.
Thank you, Your Honor.
Thank you.